I have, this is Mr. Knopfsinger's objection to the friend of the court. And there's a couple of things that I want to say before I hear from the party. First of all, you both are representing yourselves, okay? I understand that. The problem is you're making mistakes and it's not even complicated yet. And pretty soon it's going to get highly complicated. So it's at this point in time that I'm going to reiterate to both of you that you both need to consider very strongly getting attorneys because right now things are not procedurally that complicated, but they're going to be pretty quick here. This is an objection to the friend of the court. Okay. What I told you back in August of this year, I told you two things. I said, first of all, we're going to send it to the friend of the court for a recommendation and investigation. And the second thing I told you was that you're not going to get everything you want. Okay. And I don't know if you remembered that, Mr. Knopfsinger, because you've now had an independent third party who doesn't know either one of you make a recommendation and you still don't like it. And generally, I understand that. But what happens when you don't like the recommendation, a lot of people think it's going to change dramatically, and it might, I don't know. But what happens now is the friend of the court completed their recommendation and filed it with the court, along with proposed orders and a 21-day objection period on 12/3 of 24. You barely waited a week before you filed your objection, Mr. Knopfsinger, which troubles me. But it is timely. What happens from here is really up to the parties at this point. The second, or another issue I want to bring up deals with you, Ms. Goodrich. First of all, you can respond to emotion. I have no problem with that, and the court rules allow it. But that doesn't mean sending in 21 pages of text messages. Text messages don't work for me, okay? That's not how a response is supposed to be. And if you had an attorney, they would tell you you can't just send in 21 text messages, pages of text messages, and write something in the margin on each of them. That's not an acceptable answer. Then I get something today, a letter that apparently somebody wrote on your behalf. That's not acceptable, getting it one day before the hearing. I don't know when they sent it in. I can tell you, they sent that in. And the reason I point this out is this. They sent that, it's dated 12/18, okay? So I don't know when they sent it in, but it's dated 2 days ago. Court rules say all responses have to be in by Wednesday. I clearly didn't get it. Now, I'm not pointing this out to you since I didn't read it. I read everything, both of you. But you're both making mistakes here. And we're not even to the complicated part yet. Okay? So there's two avenues we can go. Number one, if the parties think that they can work out some sort of agreement with the help of a mediator, then I'll send it over there. I'll send it to mediation. If the parties don't think they can get together and come up with an agreement, then we're going to schedule it for trial. And then it's going to get very complicated. So I'll ask you, Mr. Knopfsinger, do you think you can resolve this at mediation, or do you think we should just go ahead and schedule it for trial?
I want to say mediation, but it's extremely a very hostile environment between her and I. I want to avoid trial. Like I said, it's a tale of lesser two evils here, because the only reason I filed the objection was because I had recommendation from our CPS caseworker to do so.
Yeah, I agree. It doesn't, I get it. Your objection is there, it's timely. And CPS doesn't work for me, so, I understand they are influential and they may work for, the state and they're influential to you. But, why is it so hostile, Ms. Goodrich?
In regards to the fact over the summer, for the past 5 years, I've been with my kids every day. And then after going and Henry taking away the children and keeping them from me, it is a very triggering aspect for my trauma disorder.
I don't know what that is.
And I have PTSD.
Right, well, but see, here's the problem. And if you,
And I'm working on it.
I know you are, and I appreciate that, and I commend you for doing that. Not something I want to throw out there for public consumption, though, because I don't want you to say something that would give me pause, because you two, unfortunately, you're not together anymore, but you're parents. And by the very fact that you're parents, you have to be able to work together. This child didn't ask for this. So I think what I'm going to do is this. Is there any type of PPO or anything out between you two?
Nope.
No.
Okay. Then what I'm going to do is, you both got pens? You can write this down.
Yes.
I'm going to order mediation pursuant to Michigan Court Rule 3.216 at the Dispute Resolution Center of West Michigan. They're in the phone book. And what they will do, you call them up, both of you, and schedule a mediation. And they work on a sliding scale based on incomes. So that's a good thing. Other mediators cost $300-400 an hour. So we're going to try that first. You're to call them within the next 10 days, and they will schedule a mediation for you. And then if it's unsuccessful, okay, if it's not successful, then either one of you can call or email my clerk, tell her it wasn't successful, and then we're going to schedule an evidentiary hearing for you, or a trial as we call it. Let's start there. So we'll hopefully can get this resolved. If it doesn't, then we're going to have a trial on it. I don't have any other option. I only got
Okay.
Okay. Those are the only two
Is
options.
there a way that I can inquire that Henry respond on the Our Family Wizard app and not Kathleen, as they are separated?
I don't know who Kathleen is.
That's his wife,
Is there an
and
order?
he gave her access to the app.
Okay, so there's an order for you both using Our Family Wizard?
There isn't. I bought it and paid it. He got it waived, and we were recommended by a police officer over the summer to use it and inquire about it. I just took a proactiveness and acquired it, and then implemented and asked for it to be implemented by Henry, which he obliged.
Okay, then I will order Our Family Wizard, and I'll order it between the parents only. But that's only a Band-Aid, you two, because once if it's an emergency, you can't use Our Family Wizard because you gotta have immediate response. So you both are gonna have to learn to deal with one another. Both seem like good people. I can't think of any more reason to start getting along than your child. If not for that child, who then? Who's more important to you in this world? Nobody, better not be anybody. Your child is. So you owe it to them to get this together. Start using our family wizard, both parents, call the dispute resolution center, get things written down and start following them. If not, then we'll have a trial on this. But I'll warn you both, it's going to get very complicated. Trials are not easy. Attorneys mess them up too.
I do have another inquiry.
I
His
don't
wife
have a whole
had
lot-
stated, I
Okay.
understand that, but I feel as though it is very pertinent. His wife, Kathleen, had stated that she was going to file for guardianship of AN. In the instance that she gets granted a guardianship and she follows through with that, how does that reflect this situation?
That's a perfect question to ask your attorney. I don't get into those situations. Obviously, if she did that, you would have your say in probate court for that. I can't give you legal advice as to that kind of stuff. But this is why it's going to get complicated. I don't know why a probate judge would even entertain such a thing, but there doesn't seem to me, if you have two parents that have a child, I don't know what the need for a guardianship would be, but somebody can explain that at a later date. All right, you're all set. Have a great holiday, and hopefully you guys can work it out. If you can't, then I'll work it out for you. All right?
Thank you.
Thank you.